Thank you so much for joining us for this new report from our friendly correspondents at the League of Restorative Justice. After watching their other videos about Oasis's trials and tribulations, which focused mainly on their belief that the company's CEO, Michael DaCorta, was wrongfully convicted, you may be wondering, as we have, how it was possible for a full jury of 12 to find him guilty when there was so much evidence available to show that he wasn't. Apparently, the good people at the League anticipated that question, and with this video, offer some answers for your consideration. They reveal several possible explanations. Illustrating them all took not one, but 2 videos to cover. So, this is part 1 of 2 reports entitled Facts Assumed, Not in Evidence, which is no doubt intended as a double entendre. Part 1 will cover a summary review of videos numbered 1 through 4 and begins to illustrate some of the subtle psychological tricks used to befuddle, seduce, confuse, mystify, and otherwise convince the jurors to unanimously vote for Michael's criminal conviction. It will feature reenacted segments of actual trial testimony by Oasis partner Joe Annie Lee under examination by defense attorney Sylvia Irwin, lender Jason McKee under cross-examination by prosecutor David Chi, and opening and closing statements from prosecutors Frank Murray and Rochelle Bedke, emphasizing their fairy dust storyline. Finally, it will show accurate analyses of Oasis's financial condition at the time it was seized. In Part 2, with clear explanations and illustrations using simple third-grade math, the League will debunk the prosecution's allegation that Oasis's $51 million in spread fee earnings were fairy dust, fictional, an accounting trick. They'll reveal more of the misrepresentations told to the jury and display exculpatory evidence that Michael's defense counselors had in hand, but failed to show at trial, despite the fact that doing so might have convinced at least one juror to question the fake news the jurors were being exposed to every day. Part 2 has a reenactment clip of the court-appointed receiver, Mr. Weand, giving courtroom testimony that plainly contradicted the fairy dust narrative propagated by Mr. Murray, prosecution witness Matthew Childers, and Miss Bedke. It also includes a partial reenactment of a very telling exchange between defense counsel Jessica Casciola and Mr. Weand, which took place at a hearing almost a year before the criminal trial. Part 2 wraps up with a summary explanation of why Oasis' financial condition and the status of the loans it owned belied the allegations in the civil trial that Oasis was operating illegally in defiance of CFTC regulations, and how both cases were founded upon similarly untrustworthy foundations. While it's not absolutely necessary to watch all the previous videos in this exclusive series of reports from the League of Restorative Justice, we highly recommend that you do. Taken together, they represent the distillation of over 6 years of diligent research into the terrible tragedy that beset Oasis, its owners and lenders, back in April 2019.
In this video, we will reveal subtle psychological tricks, suppression of exculpatory evidence, and a lie used to convince the jury to convict Michael DaCorta of criminal fraud. After everything we've seen, the big question is, why was Michael DaCorta convicted of fraud? Let's review what we've found so far. Video number 1. The elements of fraud showed that to convict someone of fraud, the law requires clear proof of several things, but most importantly, it must find proof of an intent to deceive. In Michael's criminal trial, the prosecution showed no evidence of intent on his part. Instead, they distracted the jury by talking mostly about Oasis's trading losses that had no consequence for Oasis lenders, highlighting the fancy buildings the company bought as assets, and by falsely informing the jury that those properties were personally owned by Michael and his partners. But all those things, the trading losses, the office, homes, condo purchases, rental properties, and businesses, were owned by the company and had nothing to do with the lenders. So how did any of that prove that Michael defrauded the lenders? It didn't. Video number 2. Terms of agreement illustrated how the jury was never allowed to focus on the most important document, which was the promissory note and agreement between Oasis and its lenders. That agreement defined the people who signed it as lenders, not investors, which the government made them out to be. That contract was the very foundation of the relationship between Michael, Oasis, and company lenders. Its terms defined the range and responsibilities of that relationship, Nothing else that was said or done superseded the terms of that agreement, and it did not require Michael to report how loaned funds were used. So, if there was no obligation for him to make reports to the lenders, how could he be found guilty for not doing so? He shouldn't have been. In video number 3, Ownership, we showed that the money loaned to Oasis became company property. Oasis used it to invest in precious metals, real estate, business ventures, and forex trades, all of which were allowed by the promissory note agreement and risk disclosures. The law requires that investor money be used to form a commodity pool like the one Oasis was accused of operating illegally in violation of Commodity Futures Trading Commission regulations. Because the money belonged to the company, not the lenders, there was no commodity pool. And without a commodity pool, the civil case, which started this whole mess, should never have existed. If the lenders didn't own the money that Oasis spent on its investments, how could they have been defrauded by the way it was used? They weren't. Video number 4. The fairy dust fable revealed that the prosecutors used a clever trick when they claimed that the $51.3 million that Oasis had earned in spread fees wasn't real. During their opening and closing statements, they told the jury that those spread fees were fairy dust. But even the government's own numbers proved that their claims could not have been true because their numbers don't add up. Their own figures disprove the notion that the spread fees were fictional. The prosecutor's argument only worked if the jury believed that the company's forex trading losses somehow harmed the lenders. But we know that wasn't true either. Given all we've learned so far, and given how apparent it has become that Michael committed no crime, how could all 12 jurors unanimously agree to criminally convict him of a crime he clearly didn't commit? That's what we're going to explore with you today. Let's start by looking at how the prosecution worked to influence the jury, not with facts, but with repetitive misleading wordplay. Lawyers on both sides frequently used, or allowed to be used, two improper words, which carried ominously misleading and untruthful implications. They repeatedly spoke of investors when referring to lenders, and to a Ponzi when describing Oasis. In just 13 days, the jury heard investor used 311 times, an average of once every 17 minutes. Ponzi was mentioned 94 times, 55 times by the prosecution, and 39 times by defense counsel. These words were thrust into the courtroom like angry hornets. These and others the prosecution used strongly insinuated wrongdoing. Spiced with emotion and laden with persuasive hints of suspicion, incriminating words stick in people's minds, even if they're not true. The words investor and Ponzi became an acoustic refrain throughout Mike's trial. If the jury believed the lenders were investors, they'd think those people still owned the money they had loaned, and by law, that might have been correct. If they believed Oasis was a Ponzi scheme, they'd naturally assume it was all a fraud from the start. But neither was true. Now let's look at another serious question. Were the jurors equipped to understand what was spoken over the course of 13 long hot days in the Florida court in April and May 2022? Throughout the trial, the lawyers and witnesses used complicated legal and financial terms like sequester, Dober motion, commodity pool, affidavit, and forex, spread, bid-ask, broker-dealer, hedge fund, and more. But most of these words aren't part of normal daily language, not for most people anyway. And here's why that matters. According to the U.S. Department of Education, 54% of adults in America read below a 6th grade level, the level of an 11-year-old. That includes 21% who can only handle the most basic reading, if any. 33% who struggle with anything beyond simple ideas. These folks can't easily make connections between two facts or draw inferences where they need to be made. Only 13% of American adults read at a fully proficient level. Now let's apply that data to a 12-person jury. 3 jurors would be likely to have trouble understanding even the simplest trial material. 4 more would probably struggle to follow complex ideas, especially when they were just spoken and not illustrated for them. Only 1 or 2 jurors may have had the reading and comprehension skills needed to keep up. That leaves only 3 or 4 jurors who may have understood courtroom language above the level of and 11 or 12-year-old, but with less comprehension than needed to understand much of the complex evidence presented to them. In short, on every day, the courtroom was filled with complicated concepts that were very likely to overwhelm and confuse the jurors, especially whenever the prosecution deliberately complicated the language, conflated words, or made the story more convoluted. It may have been extremely difficult to sift out the essential information from the irrelevant, since so much that was irrelevant was added to the testimony the jury heard. Why is this important? Because no matter how much or how little the jurors understood, they likely knew one thing for sure. A Ponzi scheme is definitely a fraud. Practically everybody knows that. Once they settled on that idea, once they were led to believe that Michael had run a Ponzi scheme, they could stop worrying about all the other complicated stuff and vote to convict on that alone. After all, it would be so much easier that way. Consequently, when the prosecution repeatedly used the word Ponzi to describe Michael's business, it created an automatic mental link in the minds of those in the court. Even if the facts didn't support it, the jurors were nudged toward the conclusion: Ponzi equals Michael equals fraud. This is one of the psychological tricks we mentioned earlier, but it still doesn't explain why not one juror voted to acquit. So, let's look deeper. Creating a story that pulled on emotions. In addition to steering them to think that Michael was guilty of fraud, the prosecution used emotional storytelling to shape how the jury felt. This was done through the prosecution's questioning of witnesses. Patty Catter, the second witness to take the stand, identified herself as an investor, even though she signed the promissory note that made her a lender. Michael's defense counsel didn't correct that critically important misnomer. During her testimony, the prosecution used the word investor 22 times in less than an hour. The defense used the word 14 more times, but the words lender or lend weren't used even once to describe her. Such non-stop substitution of investor for lender made it sound like Patty, and others like her, still owned the money they had loaned to Oasis and had a stake in how it was used. It also made it seem as though Michael DaCorta had a contractual duty to report to them how their money was being used, and especially the fact that a good deal of it had been lost in Oasis's trading activities. Even though the promissory note that Patty signed assigned no such duty to Mr. DaCorta, his defense counsel utterly failed to point that out. So the jurors were left to believe it was true, even though it wasn't. Wasting time on irrelevant testimony. On the same day that Patty Catter appeared, Jennifer Sunu testified about the authorities of the National Futures Association, NFA, and the Commodity Futures Trading Commission, CFTC. Her statements were only relevant if Oasis had investors or ran a commodity pool. Not only was neither the case, but the prosecutors also made it clear to the judge at sidebar that they weren't going to accuse Mr. DaCorta of operating a commodity pool. Unfortunately, that admission was done out of earshot of the jurors. Instead, the jury heard Ms. Sunu's very long explanations about the CFTC and NFA's authorities as if they were important, when in fact they were irrelevant, and the sidebar objections made by Michael's defense went unnoticed by the jurors. They were left to believe they'd heard something significant, but they hadn't. It was just more chaff thrown into the courtroom to make it seem like there was more substance to the issues at trial than there was. Also on day 2, prosecution witness Matthew Kienke was described as an investor 7 times and never clearly identified himself as a lender, even when asked directly. Pulling the jury's heartstrings on day 7, Anthony Charles took the stand. He was introduced to the jury as an Irish immigrant, the father of 3 young children, a retired carpenter with severe back injuries, and someone who hadn't read the promissory note and didn't understand what he had signed. He kept calling himself, and others, investors, even though they weren't. But he told a sincere, emotional story about wanting to use earnings from Oasis to send his son to college and otherwise care for his young family. The jury probably felt sympathy for him, even if he misunderstood the facts, and little or no effort was made to correct that problem. Also on day 7, Oasis partner and attorney Joe Arneely gave confusing and conflicting testimony. On the prior day, He said that Oasis owned the loaned funds and had no obligation to report how those funds were used. But during cross-examination on the 7th day, his answers got murky. Here's the original exchange, exactly as given.
Why would it be egregious to tell the lender all the ways that you intend to use their money?
Well, if you present this to an average investor, and you say that I will ask you to sign an unsecured note where you will loan me money and I can do anything I want with it, there has to be a reason that the lender would agree to do that.
These were not being presented to average investors. They were being presented to possible lenders.
Possible?
Lenders. They were loaning their money.
Well, I assume an investor who wants to make money from it, yes.
That exchange made things even more confusing, especially for jurors already unsure about the difference between a lender and an investor. And that confusion worked in the prosecution's favor. The misleading lies. Let's talk about what may be one of the biggest deceptions presented to the jury during Michael DaCorta's trial. A false claim about an audit that never happened, and the truth the jury never saw. When Jason McKee took the stand for the defense, he raised a key question.
I always ask the question, why didn't they just come into the office, to Oasis headquarters? Why didn't they come in and close down the books and say, hey, why don't we do an audit because we need to understand what you guys are doing, and from what we find here, then we'll make a judgment whether or not there is a crime being committed. But they didn't do that. They come in and just shut them down, said it was a Ponzi scheme, took all the money.
Sir, on direct examination, you told Mr. Allen that you would have preferred if at the outset an audit would have been done on Oasis's books and records. Isn't that correct, sir?
That is correct.
Are you aware, sir, that in fact a government entity, the CFTC, did such an audit?
Not aware of it.
And, sir, you are not aware of the CFTC's findings in this case, are you?
I read their complaint.
And the CFTC is the Commodity Futures Trading Commission. Is that correct, sir?
That is correct.
And the CFTC's audit, sir, you are not aware that they determined that Oasis had an $88 million deficit? And I will ask that question again, sir. You are not aware that the CFTC did in fact do an audit and found an $88 million deficit upon an inspection and an examination of all of Oasis's books and records. You're not aware of that, are you, sir?
No, I'm not.
And you're also not aware that according to the CFTC's audit of all the books and records of Oasis, that Oasis only had approximately $17 million in assets. You are not aware of that, are you, sir?
I'm not.
Here's the truth. There was no complete audit in any form of evidence ever provided, not in the civil case nor in the criminal. The government did not account for Oasis's full financial position. They never produced a balance sheet showing all the company's assets. Instead, they relied on an uncertified analysis of Oasis's internal financial records containing no verification of the value of its physical assets like real estate, gold and silver, and company-owned businesses. An unverified declaration by Elsie Robinson was used to open the civil case, without a certified professional audit to back it up. In fact, no full accounting of Oasis assets was ever presented at trial. No company-wide balance sheet, not even one built from the government's own numbers, was shown to the jury or given to the defense. Yet, when specifically confronted with that, a government attorney told the jury otherwise, and again, no defense counsel objected to that falsehood. So the jurors were left to believe it. Worse still, an Oasis balance sheet, painstakingly constructed from the government's own figures which took into account every deposit and withdrawal Oasis had ever made, shows that the claim of $17 million in assets, asserted without objection by Mr. Chi, was wildly inaccurate. The summary cash figures were these. They do not include Oasis's other assets. Trading account deposits, $22,275,000. Adjustments to account by ATC brokers, $16,591.37. Spread fee earnings, $51,307,025.93. Gross deposits, $73,595,517.30. Trading losses $62,314,807.11. Brokerage fees $5,277,627.89. Rollover interest charges $4,002,082.30. Gross losses and fees $71,594,517.30. Ending balance $2,005,000. So, while the jury heard that a government audit had proven an $88 million shortfall, the truth is that despite the fact that the IRS, the FBI, the CFTC, the court-appointed receiver, and the defense counsel all having had access to Oasis's financial transaction records, no certified audit was ever done, no complete asset review was presented to the jury, no certified financial records were presented to back Mr. Chi's claims, and, though a carefully constructed balance sheet proved otherwise, it hadn't been completed by the time of the trial and was never shown to the jury. The fairy dust lie, debunked by math. In video number 4, The Fairy Dust Fable, you saw how prosecutor Frank Murray distorted the definition and denied the existence of spread fees Oasis had earned. In his opening statement, he said,
"The evidence will establish that in this case spread pay, or pips as they're called in the industry, was pretend, fairy dust, an accounting trick."
That's like calling a yardstick inches or a loan dollars. It's like calling a marathon miles or a cake flour. Pips are simply the units used to measure spread fees, not the spread fees themselves. In her closing statement, lead prosecutor Rochelle Bedke echoed that same falsehood. She said,
"Told you that the spread pay was illusory. It was a fiction. It was like fairy dust."
This isn't rocket science, but we'll ask a rocket scientist to show you, with simple math, why that statement could not be true.